Hi everyone and welcome back to the channel. My name's Jay, the Principal Migration Lawyer here at Flow Migration Law. Applying for an Australian partner visa is a journey filled with hope. It's about building a future in Australia with the person you love. But as today's story shows, sometimes the smallest, most innocent decision can lead to very serious complications. I'm gonna share a real life experience from a couple we assisted. It's a story about a last minute application, a simple payment choice, and how being just one day late can push you into the very complex territory of the Schedule 3 criteria. It also shows how a path forward can be found. Let me introduce to the couple. They were in a strong 3-year de facto relationship. The applicant was from Taiwan, here on a temporary graduate visa, and her partner was an Australian citizen. They had truly built a life together here. In fact, they had just taken the huge step of buying their first home. As you can imagine, with a new mortgage, both of their incomes were essential. They prepared the partner visa application themselves and did a diligent job gathering all their evidence. As the expiry date of the applicant's visa got closer and closer, they were also saving up for the large government application charge. They found themselves ready to lodge on the very last day of her visa. So it's the final day. They're logged into their EMI account, ready to submit. When they get to the payment page, they have a choice. Pay by credit card, which would add a surcharge over $100, or pay by BPAY and save that money. For a couple with a new mortgage, trying to save a bit of cash is a perfectly understandable decision. So they chose BPAY. They submitted the application form, made the BPAY payment, and assumed everything was done. But here is what they didn't know. A BPAY payment to the Department of Home Affairs is not instant. The payment wasn't actually processed and received by the department until the following day. By then, her visa had already expired. Because the application was officially acknowledged one day late, she had been in Australia for a 24-hour period without a substantive visa. This made her become an unlawful non-citizen. That single day triggered Schedule 3, and her life was immediately turned upside down. Instead of getting a bridging visa A with work rights, she was granted a bridging visa C with no permission to work. Panicked, they came to us. This is where things get technical. So let me break it down. Schedule 3 is a set of extra criteria that applies if you apply for a specific type of visa, like the onshore partner visa, while you're in Australia without holding a substantive visa. To get the visa granted, you can't just prove your relationship is genuine and continuing. It's not enough. You now have to overcome these additional, very specific criteria. Our job was to build a strong legal submission addressing these criteria. First, we had to show she was eligible to be considered for the Schedule 3 requirement. She applied for the partner visa within 28 days of her substantive visa expiring. From there, we had to argue that she had become unlawful due to factors entirely beyond her control. We argued that a government payment system's processing delay was exactly that. We also showed she had substantially complied with her all previous visa conditions and visa expiries. Most importantly, we had to articulate the compelling reasons for the visa to be granted despite the late application. Our first priority was their immediate financial hardship. With the applicant on a bridging visa C and unable to work, their household income was suddenly cut almost in half. Their new mortgage was at risk. So we immediately lodged a separate request for work rights based on these financial hardship grounds. Thankfully, the department acted quickly and her permission to work was approved. With that fire put out, we focused on the main problem, the Schedule 3 submission. We worked closely with the couple to detail the timeline of events, providing evidence of their attempt to pay on time. We built a powerful case around the compelling nature of their relationship, their shared home, and the unintentional, out of their control reason for the one-day delay. The result? The department accepted our submission. The Schedule 3 criteria were met, and their subclass A20 partner visa was granted. They could finally breathe and continue with the life they had worked so hard to build. This story had a positive outcome, but it holds some critical lessons. First, be aware of payment processing times. A BPAY payment is often not an instant transfer. When you're near a deadline, paying by card is often the safer method as it's processed immediately most of the times. Second, Try to avoid lodging on the very last day. System issues, internet outages, or a payment problem can cause a disaster. Third, one single day can change everything. It was the difference between a standard application and one facing a BVC, no work right, and the real possibility of visa refusal. And finally, the couple acted quickly to get help. This allowed us to address the work rights issue and prepare a persuasive submission right from the start. This couple's story is a powerful reminder of how small details in the migration process can have huge impacts. If you find yourself facing a difficult situation like a Schedule 3 issue, understanding your options is your first step. We invite you to reach out. As the principal migration lawyer at Flow Migration Law, with over 8 years of dedicated experience in Australian migration law, I have helped many people navigate these types of complex matters. For legal representation on complex cases like this, you can email me directly at js@flowmigrationlaw.com.au to book a consultation. Thank you for watching. If you found this video helpful, please give it a thumbs up and subscribe for more. I'll see you in the next one.